The topic for today is whether you should sue a client for unpaid fees. From the perspective of the insurance carrier, malpractice insurance that is, the answer is an obvious no. The reason for that is, statistically, according to them, you will almost get countersued for negligence when you file a complaint for unpaid fees. There are some technical or tactical approaches you might take. One is, depending on the state of the law in your jurisdiction, to wait a year for the statute of limitations for negligence actions to be passed, and then file your complaint for the unpaid fees because it's on the basis of a contract, and generally speaking, the statute of limitations for contracts is 4 years. Again, look at your particular jurisdiction for the time frames relevant to your particular matter. But I think that this discussion misses the entire point. First of all, it seems to me that the engagement agreement, something everybody today agrees you ought to have, a written engagement agreement, is a contract. And it's a contract with responsibilities on the side of both parties. On your part, you've got to agree to perform your services in a workmanlike manner. You've got to respond promptly to the client and the client's needs, and so forth. But I think what most attorneys fail to recollect is what the client is supposed to do. The client is supposed to tell you the truth. The client is supposed to submit timely documents that you request that are needed for his or her proper defense of their position. And thirdly, and certainly not last, they need to pay you your bill timely. That's their agreement. And one of the things that I encourage lawyers to do is to specifically point that language out in the engagement agreement and have the client initial in the margin that particular paragraph. So, assuming now that the client recognizes their obligation to pay, when is it, if ever, you should sue a client? Well, first of all, when you're right. That is, when the client stops paying you and all efforts on your part have gone for naught. Of course, another way of dealing with this is to make sure that the client never owes you a lot of money. In other words, quickly and timely address the issue of unpaid fees so that you have the option, really, of walking away from the matter and losing a few $1,000s, perhaps, or then pursuing it to a lawsuit perspective. Now, one of the things I think you have to understand, though, before you do file suit is why is it that the client's not paying your bill? It may be that they never received the billing. Unlikely, but it's possible. And you need to check that out. If you take a look at my book, Collecting Your Fee, Getting Paid from Intake to Invoice, you'll see a script, if you will, that I have written, and it has 4 or 5 steps in it that you ought to take before you even consider whether to file a suit against the client. Also, you don't want to file a suit when the client has no more money. If, with all of your investigation, with all of your due diligence, you entered into an attorney-client relationship when the client had funds and was able and capable and willing to pay your bill, but something has happened in the meantime that their business has gone south, that's not a time to file a lawsuit. That's an exercise in futility, if you will. My point in this discussion is to raise the possibility that filing a lawsuit is not a meaningless act, and it is not unprofessional, as some people might say. In fact, I was just reading in a major news publication a couple of days ago that even some of the major law firms today are filing lawsuits against their clients. The problem with them, however, is that they are suing for very large numbers. And all that tells me is that there was a poor management process in place that allowed the client to pile up a debt to the law firm of such magnitude. So in summary, take a look at your engagement agreement. Make sure that you've honored everything you're supposed to do. Look at the client's file. Make sure it is free from any claims of negligence. Number 3, take a look at the client to make sure that the client really does have the funds and is capable of paying the bill. If so, nothing wrong with filing a suit against a client that has not honored their agreement. That's what you do every day of the week. Thank you.